On court today, Judge Simpson takes the bench, and the tension is high.
Is Israel Crane.
We're ready in this matter. Warren Brown, Deputy Chief Public Defender, being with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
To the best of our knowledge, Your Honor.
All right. People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
Your Honor, I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother. I do want to note that I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on an previous.
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yes.
But the content of those particular phone calls, we don't know.
I have not had the opportunity to listen to them yet.
Mr. Brown, I'm not sure what they're asking.
I think they're asking for his phone privileges to be revoked, but they haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out there. Here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third party contact. So maybe if you get a statement from the officers to how they know that, what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture. This is Deshaun McFarland.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. McFarland. Sir, what's your name for the court?
McFarland.
In this case, Your Honor, we're asking the court to please set for exam. Discovery should be complete.
That is correct, Your Honor. Discovery.
People would have their witnesses available the 25th. Preliminary examination, June 25th, 2024, 9 a.m. before Judge Washington.
Your Honor, there is one matter.
Of course you would. Go ahead.
Your Honor, I do want to note that there have been no calls directly to the victim. However, I do have notes that, and I did notify Mr. Burns Then I have this as well as request to have the jail clothes released to him that the defendant has been talking to his grandmother and informing and instructing her to contact the victim about dropping the PPO. I am extremely concerned. This is not an isolated phone call, but it seems to be repetitive and continuous and come up in multiple conversations. As a result, I also want to follow up and say that it does appear that the victim was contacted by the grandmother, according to later conversations, and that she said she would not be dropping the PPO. She wants to keep it in place for a year and see how he does. But at this point, it's not just a request for indirect contact, it is successful indirect contact. I would be requesting for his phone for this to you.
Well, it certainly hurts the bond argument that I was planning on making today, Your Honor. I don't have a response. Let me give that.
Well, I'll just say this. I'm a bit concerned that the contact was made. And that the contact that's made is of a nature that is obstructive. It wasn't just, hi, how you doing? That concerns me. So two things are going to happen here. Defendant's phone privileges are hereby ordered revoked. Defendant's bond is also increased to $200,000 cash surety.
You gotta stop. You can't say this.
Thank you. Case people versus, is it Hazel Jacobs?
Assistant Public Defender on behalf of Hazel Jacobs, who approaches.
Take your name.
Mr. Jacobs. Thank you. Your Honor.
Yes.
I'm so sorry. Just looking for my notes on this one. I do know that, Your Honor, if we can be heard on bond after this, I would be appreciative. And I understand that there is an alleged violation that we need to go over. We would like to. You want to waive or hold your exam? I tried to get a hold of my client, Your Honor. I was not able to explain to him because we didn't know that he was in the jail until late yesterday. So I have not been able to talk to him. I would ask to adjourn this for 1 week so I can go over everything with him and explain exactly what the next options are. So if we could just get 1 week, that'd be. I wouldn't.
June 20th, 2000.
Not right now. You stop talking. Listen, I have the information.
June 24th, 2020. June 20th, 2024, 9 a.m. for probable cause.
Thank you, Your Honor.
This time you want to address, you didn't want to address bond, did you? I have a conditional violation. If you want to address it, you can go ahead, but.
I understand, Your Honor. As it pertains to the conditional violation, my client would have me advise the court that with regard to the report that the court is in receipt of, the argument involving the subject of the no contact order, which was heard by his neighbors, occurred while he was not home, occurred while the individual he has the no contact on was arguing with someone that she was talking to the phone on. He advises that she was at home without his knowledge and that he came home to find her there. It advises that the ensuing argument resulted after she started screaming and crying when he asked her to leave so he wouldn't violate his conditional bond, Your Honor. Additionally, he advises that he has orientation for a new job next week and he will be unable to gain an income used to support his father and child if he loses that new job, which will happen if he does not attend that orientation. So he would be asking for a release based on the information that the court's in receipt of.
Response from the people.
He was home. He told the police that he was home. He actually told the police that she's the person he was arguing with. He actually went on to tell the police that he's the person she was yelling at. I'm not sure why he doesn't remember talking to the police. I'm not sure why he doesn't know that the police would write a report to that. But that all of us have this report, including all of his admissions to being and having contact with her. So yes, this occurred at his apartment. However, he was there. The police spoke with her and spoke with him. And the police arrested him for having contact with her. And that's when he went on to admit to them that he was in an argument with her, that she was screaming at him, and he acknowledged the no contact order with her. So that's the conditional violation. The other reason that Your Honor should continue the defendant's bond as it currently is ordered is because when my office charged this case, we requested $25,000 cash surety on this, and we're not given that information. This is a case where the defendant is charged with strangulation. It reported to the police. The defendant was punching her in the face, got on top of her, while she was laying on her back on the bed. The defendant was on top of her, pinning her arms on the bed and using his other hand to choke her. She told the police that the defendant squeezed her throat with his hand and then started using the blade of his forearm, so it's the bone there, to apply pressure to her throat. She said she punched him in the face in an attempt to get him off of her, and that she felt that she was being choked for approximately 30 seconds while she struggled to breathe. The police noted in their report that the victim's throat was covered in scratch marks and light red bruising. She indicated she did not lose consciousness, but she had to fight him off on her bed. And then the defendant, while she was trying to fight him off of her, the defendant went on to bite her right shoulder. The police officer wrote in the report, "I observed what appeared to be an obvious bite mark on her shoulder, visible teeth marks and bruising." It goes on. The victim continues to report that even after that, punching her in the head. The officer does a great job of, as she's reporting what occurred to her, keep that in his next statement. He's on to report what he observed. He says, "I observed raised bruises or goose eggs on the side and back of her head." And it continues. So, Your Honor, we requested $25,000 just based on the facts of this case alone, as well as the danger that the defendant presents to not only this victim but the community. But then he goes on to have contact with her, make admissions to the police, and come before Your Honor and try to tell us a different story. So I'm asking that Your Honor not reduce bond in any way this time. Thank you.
Your Honor, may I respond to that?
No.
Your Honor, as it pertains to the allegations of the alleged crime here, a determination was made by the magistrate as to his release. He was out. We don't deny, as it pertains to the allegations on the bond violation, that any of that happened, other than the fact that he arrived home from a haircut and she was there and he tried to get her to leave, so that he wasn't in violation of that bond condition. He advises that he has a tether. He's willing to do home confinement. We just would ask for consideration and his release.
No, he was brought in on the conditional bond violation. It was not arraigned before the magistrate on the conditional bond release.
I'm sorry. I didn't mean to cut you off. I'll stop talking.
Go ahead. What were you going to?
I was just, with regard to the original charges, Your Honor, not the bond violation.
Right.
Okay.
But taking all that into account, what the story that just relayed to me doesn't match the police report at all. In regard to what the defendant is having counsel put forth to the court.
Okay.
Because of the conditional bond violation, taking that into account with the allegations, at least as it regards this particular case, the court's going to set the defendant's bond in the amount of $50,000 cash surety. And we'll see him next week.
Thank you, Your Honor.
This is Omar Anderson.
Good morning, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Anderson, who is approaching. Could you state your name for the record?
Omar Anderson. Thank you.
Your Honor, I was just informed last night that there are some jail calls that were delivered to my inbox after the beginning of this docket today. So I would like to ask for an adjournment so that we can listen to those and decide on how to proceed from there.
Go ahead. What?
That is correct, Your Honor. He was arraigned on May 31st, and between May 31st and prior to his release on June 3rd, including on June 3rd, he made 8 calls to the victim. I do want to note that the underlying allegations here is that he had a valid and served PPO protecting the victim. At that time, he came out and threw a brick through the back windshield of her car, which damaged the front windshield of her car as well, and then fled the scene. Since the calls from the victim, to the victim from when he was in custody, she has since filed to terminate the PPO, and he has been out. I am extremely concerned that
I just want to make sure I'm clear. There was a PPO.
Correct.
He is lodged at the jail at some point.
Correct.
From the jail, there are calls being made.
Correct. After his arraignment.
Go ahead.
I am extremely concerned at the potential for undue influence on the defendant's part over the victim in this case.
Counsel, anything?
Your Honor, as I have not had a chance to review any of the information, I just know that there were calls. Again, I would ask for an adjournment.
But how many calls between the time that he's incarcerated and arraigned and released? How many calls?
8.
You have copies of the calls?
They were just released this morning.
I have not had a chance to download them.
Because I'm going to let you know, Mr. Allen, my inclination would be to remand him pending some resolution as to what's contained within those calls, because he shouldn't have been contacting her at all. Yeah, the defendant's bond at this point will be revoked, because I think that his bond, there would have been differences. I need to figure out what's in these calls. And here's the reason, Ms. Reed, I want to figure that out. There are these calls being made. There's a PPO in place. There are these calls being made. The PPO is then requested to be lifted, and then this case is still here. And there's a lot of little flags raised by that. So I'm going to revoke his bond. I will give you an opportunity to, whoever in your office, to try to get through those calls. And then I will consider at any point in time, a request to change that or to do something else. But I think everybody needs to hear, or at least try to hear, what's on these calls. All right.
Do you want me to release the calls to your chambers as well, or?
Why don't you? Because that would then speed up the process if Ms. Reed has something that's in the calls or something that she wants to say why or whatever, or the people for that matter. I don't have to then try to reach out and get them. So yeah, why don't we do that? You wanted this adjourned, correct?
That is correct.
All right, since I'm remanding him, I'm going to put it out just 1 week to the 20th.
Thank you.
So probable cause will be adjourned to June 20th, 2024, 9 a.m. or if your invite indicates bond is revoked at this point. Defendant's remanded.
I don't think the calls right.
Can you give the keys to
Privileges, right? It's revoked his back.
I just revoked it.